and welcome to Thursday Live with Chugh. My name is Neha Mahajan, and I'm the Business Development and Outreach Manager. I'm based out of Edison, New Jersey. But today, joining me from Texas, Houston, Texas, is Ashima Chock. She's a partner and attorney with the firm. And from Santa Clara, it's our partner and attorney, Kirti Kalra. Welcome, everybody.
Thank you.
Thank you.
Yeah, and a very good morning to everybody who's joining us from the West Coast, and a very good afternoon to everybody who's joining us from the East Coast. Today, well, we're going to be talking about non-competes. Who gets to pay the fees in H-1B? Is it the employer? Is it the employee? Like, you know, there's always this tug of war, so as to say. You know, sometimes employers deduct whatever immigration related fees there is from employees' salaries in an indirect way. Is that the right way to do it? Are there any repercussions to it? Is it even legal? You know, we'll get into the details. We'll discuss all about it. But first, we'll start with some news. Kirti, off to you. What's the news?
Well, the March visa bulletin came out yesterday, and I think it was yesterday or the day before, but there weren't as much changes as everybody was expecting. The only thing that really moved was the final action dates for EB2 for about 4 or 5 months, went from January to May for whatever year it's been stuck in for a long time. Besides that, I think there was really no changes. The filing dates all remained the same. And I think that might be due to the amount of application they're still receiving for adjustment of status. Other than that, there's really not much on the visa bulletin. I think the only thing to keep in mind for everybody is that even though there wasn't a lot of change in the visa bulletin, interfiling is still in full-fledged. People are, not necessarily, waiting on their particular category. By interfiling, they're moving on to different categories, and that's pretty much the hot topic right now for the visa bulletin.
Yes, absolutely. And especially for those who were born in India, it's a big deal because they've been stuck here for more than a decade. And this is actually, fresh air for them, right? This is
For the last
welcome
few
news for them.
years, it's been that way. Yeah, the last few years, ever since they moved in October, there's been this new revival of hope and even interest towards filing green cards because people were losing faith in it. People were saying, man, it's going to take 10, 15 years. I'd rather go to Canada or somewhere else to pursue my career. Because nobody wants to be in this limbo for 10, 15 years. But because of the movement, there's a renewed interest. There's a lot of people coming on board. So yeah, it's exciting times for people that have been waiting for their green card.
Yes, I mean, there's something to be thankful for. Because of COVID, that these dates have moved on. So I would say because rules haven't changed. Nothing's changed with the law.
Right.
People have been trying for the longest time. So nothing's changed there. It's just the whole COVID situation has made immigration for employment-based immigrant visas a possibility for a lot of us. So that's good news, right?
Right.
And then the H-1B cap season, that's about to begin March 1st, I guess. That's when the registrations would begin. But I guess the biggest discussion is around who bears the cost. Is it the employee or is it the employer? Because I guess that's where everybody kind of tussles together. Now, can employers seek reimbursement for H-1B costs? And then all the visa expenses that employers must cover, what are those kind of visa expenses, right? And whether non-compete agreements are enforceable for H-1B workers. This is what we're going to discuss today. Kirti, I want to start with this discussion. The H-1B, it's an employment-based visa, and you would imagine that the employer would bear all the cost, but is it so that apart from paying the monthly salary, an employer is also liable to pay for any immigration-related fees that they must incur to keep that employee literally, on
No,
status in the United States of America. Is that true?
absolutely, absolutely. Cost of retaining talent has gone up significantly, whether it's adding benefits or adding salary increments at a higher clip, especially in the last year or so. That's just been exacerbated. Employers are under a lot of pressure to keep the talent, but at the same time, not burn through all their money and not lose their talent, because what what employers rely on is their people. I mean, most businesses are people run, and they rely on people. So to keep them is essential. Now, I guess where it gets a little murky is, along with this task of retaining talent by offering great benefits, great salary, flexibility. Um, some of this talent has to come from overseas, because simply in the tech field, tech sector, where we mainly operate out of in our Chugh firm, um, you know, they have to pay additional fees for the visa filing fees, which can be quite significant depending on the size of your company, and they vary based on that. Now, how much of it can the employee pay for? Answer is close to zero. The reason I say close to zero is because there's an exception to it. And one exception is the premium processing fee. Even the exception to the exception is that the employee can only pay for the premium processing fee if it's for the employee's benefit. For example, the employee needs to travel, he needs the approval before he leaves, or the employee stuck outside the country, he wants to come back in quicker. So they can pay for the premium processing fee. But if it's for the benefit of the employer must pay for the premium processing fee and cannot pass it on to the employee.
Right.
So, I
And
mean,
all
the
of this
short
adds
answer is,
up.
yeah,
Yeah.
no, the short answer is, yeah, the employer cannot push the cost on to the employee. It's an additional cost that they must, and you're right, it adds up quite significantly, depending on how large you are as an employer. And
Yeah.
yeah,
Yeah. I mean, it's ginormous. Just the whole, except for the USCIS filing fee, you also have attorney fee, and then some sort of administrative costs associated to it. And then
right.
so all those really, what's coming to my mind here is, Kirti, all those who call H-1B as cheap labor. Well, here there's a lot of cost associated with
Oh, it's
retaining the
definitely
talent.
not cheap labor. Yeah, it's definitely not cheap labor. In fact, some of the complaints that we get is the employers say that, look, the prevailing wage are out of touch with the real wages. Prevailing wages are much higher in case of H-1Bs than oh, than salaries of green card holders or citizens. And on top of that, we have to pay the all of these additional fees. It's insurmountable. It's never been cheap labor, and I think it's
Yeah.
just a misconception. And to be fair, it's been abused in the past, where people incorrectly use the H-1Bs and Ls, where they miscategorize people or file them out of different locations. That's all fraud, right? So that,
Yeah.
aside from that, I would say most of the H-1Bs and Ls are used properly, and they're not cheap.
Yeah, absolutely. And I just want to reiterate here that we are live. We are live on YouTube, Facebook, and LinkedIn. So wherever you're watching us, drop in a hello or a comment or a question that you may have. Our attorneys are here live. Kirti Kalra, a partner and attorney from Santa Clara, and Ashima Chock, partner and attorney from Houston, Texas. Kirti, following up on the whole fee discussion that we are having, who gets to pay the bill, really? Can employees be made to pay the attorney fee?
No, no, it's all about procuring the H-1B visa. That involves every type of fee there is, right? So whether that's the Acquia fee, the fraud fee, anti-fraud fee, sorry, the filing fee, public law fee, attorney's fee, they're all included. It just it's too it's the cost that they must bear, and it's to prevent any sort of it's the safeguards around these fees, so that they don't get passed around in one way or another. They're all
Right.
covered.
So, what happens to those employers who pass the buck to the employee and makes it
Right.
sound that they're making a huge favor to these employees.
Right.
And well, we'll cut the salary, we'll cut the money through your salary. You can pay it to us in installments, and the talk around it. What I mean, it's an employment based visa, right? And an
Right.
employee, from an employee perspective, they're scared. They don't want to lose the job because that'll jeopardize their visa status. So it's kind of a tricky situation there, right?
Right. No, and what happens to them is fairly uh, it's fairly big, right? For example, what I tell employers when they say, "Hey, why can't we pass it on?" or "What's the deal?" Can we just make them bear some of it? I don't have to bear this for everybody. Why do I have to bear for them? I simply tell them this: it's the equivalent of an employee showing up to work and then you asking them to pay for their laptop or pay to use the desk that they're working on. At that point, they're not employees; they're contractors, right? So that's kind of what I try to tell them. If it's part of what it takes to make an employee. Now, it's additional cost, and if they pass it on in the course of a DOL audit, it will definitely come up. In the course of a USCIS site visit, it will definitely come up, and the repercussions are huge. Not only will the employer be required to pay back wages, on top of that, they would be required to pay additional fines and penalties. And in severe cases, they can be disbarred from using this visa program. It is not something that every employer is entitled to. In order to use this visa program, they must follow the rules. And if they violate the rules for the visa program, they will lose their ability to use that program to retain talent, which clearly they need. If they're going through these steps to get these individuals from overseas, they clearly need this talent. So um, being disbarred is a pretty serious thing, and it's normally followed by a huge amount of fines.
All right, employers, I hope you're taking note of that. You are liable to pay any fees that comes with retaining an H-1B talent and making sure their immigration status is up to date. Now, is there any fees that an H-1B employee must pay?
Um, must pay? No, there are no fees that the employee must pay. Like I said, the only thing that they could pay for is the premium processing if it's to their benefit. And if it's to the employer's benefit, the employer must bear the premium processing fee.
All right. And I just want to reiterate we are live on Facebook, LinkedIn, and YouTube. And this discussion that we are having today is for informational purposes only. If you have any questions that you would like for us to answer, our attorneys are here live. You could drop them in the comment section and we'll be happy to answer them live here. Or if you're watching a recorded version, info@chugh.com. That's your best friend. Just send us those questions there and we'll make sure we set up a consult and get to know more about your situation and get you just the right kind of advice that you need. And the discussion that we are having today is in no way a client attorney relationship. Like I said before, this is just for informational purposes. So Kirti, so the H-1B employee doesn't necessarily pay for anything, but maybe, like a premium processing fee if they really want to go that route, right? Now, we know that an H-1B is an employment-based visa, right? Are there any restrictions to how many hours can an H-1B work? We typically think that H-1B is a 40-hour a week employee. Is that what it is? I know there are some exceptions, and I want you to tell us more about it.
Right. The same rules about exempt employees and non-exempt employees apply to H-1Bs. I think the major restriction that comes up and the major issue that comes up with H-1Bs, specifically H-1Bs, is that um, the the relocation of employees. Now, we're in a very fast-paced environment. Employees have to travel for work and they relocate. In fact, they're coming here to work in the first place, and then they get sent to different sites and different locations. Some of our clients, which are mainly software and hardware developers, they have to send their employees to client sites to implement some projects. Some of those projects last months, some of them last a few weeks. And what you have to be careful about is whenever they go to a client site or different office within the company, that you file an H-1B amendment. The reason for that is every site is governed differently in terms of the amount of wages must be paid for that location for that particular job.
Yeah.
So a software engineer in, for example, in San Francisco, which will come into San Francisco County, would be paid differently than a software engineer in, Orlando, Florida.
Yeah.
So we just have to make sure that the wages are covered based on the locale, which would normally require a new labor condition application, which must be filed with an H-1B petition. Getting very detailed here, but key
Yeah.
thing to keep in mind is that with H-1Bs, before you relocate, check with your attorney. An amendment may or may not be required. You need to file those before you go ahead and relocate the employee.
All right. And the employer bears the expense, right?
Of course, any H-1B, subsequent H-1Bs, all the H-1Bs you can imagine that come with it, and some of these do add up over time. While they incrementally go down because depending on how many extensions, is it the first extension, second extension, but they do add up quite a bit. As you know, a lot of these foreign workers are stuck here on H-1B for quite some time, waiting for the visa bulletin to become current. So some
Yeah.
of them get 4, 5, 6, 7 extensions before they get to their H-1B. So
Absolutely, absolutely. Thank you, Kirti. That's been insightful. And Houston, we have a problem here. Ashima, you've been patiently waiting for me to ask you some questions, and thank you for that. We've seen some cases where employers they make their employees or force their employees, kind of like arm twist their employees, really, to sign a non-compete, right? And what is a non-compete, first of all, and is this even legal to do?
Before I get to the non-compete, I would just like to comment on what Kirti had said about enforcement on paying on the fees and audit. So I actually had a case where the employer sued the employee when he left for getting the money he paid for the fees back. So in that case, not only the contract was voided, but I also got my attorney fees because it's a violation of LCA and the federal law that you ask for fees from your employees. So I actually got the attorney fees for that. Now I'll come back to non-competes. I just wanted to make a comment on that.
do you mind if I
So
add something to that? Sorry.
Yeah.
And this is the employee went through an attorney, got their attorney fees to get paid for. Now, had the employee gone to the DOL, they would have opened a much broader investigation, not just for that employee themselves, but for all the other employees that have been maybe underpaid or fees recouped from. So you can imagine how quickly this can escalate. Sorry, go ahead. I thought I
yeah, I
added
think
that.
No,
you're right. And I think that was the reason why I got paid attorney fees and had the case settled. So that doesn't happen.
yeah. Oh God, yeah. So this can go. Employers might think they're saving pennies here and there, but this could turn out to be something really against them in the long run. So employers, beware.
So coming to non-competes, so non-competes are really restrictions on trade. They can take different forms. You can have non-competes when there's a business merger. You can have non-competes when there's a business divorce. There are non-competes in employee-employee relationships. So, but for our purposes, we just going to limit ourselves to the context of H-1Bs because we're really focusing on H-1Bs and non-competes there. So H-1B is an employment right. So it's a federal law which governs H-1B. So, and like Kirti had mentioned, you have to file a LCA before we can even have to determine the prevailing wage. And Kirti briefly mentioned that the prevailing wages are too high, but you still have to comply and pay. So the federal law states that you really can't have restriction. You cannot force an employee on H-1B to stay with you. But if the employee leaves you, you can have liquidated damages. And that would be governed by the state law. So the non-compete is really when employees say, I'm an employer-employee relationship and I leave my employer and go join somebody else, they would have a contract saying that you can't go and join my competitor. So these are really restrictive movements. So the question comes, can they have a non-compete, where they say, okay, you can't go join my competitor or you can't go work somewhere else in the same field for 10 years, 15 years. Are they valid? So I actually had a case where that was a different case, not from the one I said. So in this particular case, what had happened is the employee was an H-1B. It happened about 2000, I think in 2007, around 2007, the numbers became current. So everybody wanted to go file, whoever was filing green card wanted to file 485s. So in this particular case, the employer said, okay, I would I'll file on your behalf the green card application as long as you pay the liquidated damages if you go and work for somebody else, or you leave me, or if you leave, at least you have to work with me after 2 years until you get your green card. So
Yeah.
that was a provision in that particular case. So I thought that was quite unreasonable because it's more like duress. So you want to keep your job, you want to file your petition, but you are kind of bound to sign it because you're under so much pressure that you want to get this done. So this particular case, the employee had signed the non-compete, but my argument was that this was duress and you can't just make the person sign, and it was voided, the non-compete clause. So every state has their own law. The federal law requires that you can have liquidated damages. You may not be able to enjoin somebody. You can have liquidated damages, but it has to be according to the state laws. Now, each state law is different. It doesn't matter. I'm in Texas. I can tell you about Texas law, but every state is different. So in Texas, non-compete is really a covenant in the contract. You have to comply with the contractual principle or contract, the basic. Any non-compete has to have a consideration. You cannot have a non-compete without a consideration. And it must be valid, reasonable. There has to be some legitimate business interest which you have to protect.
Yeah.
Now, apart from this, in Texas, for physicians, if you can have an H-1B on physician,
Yes.
right? So in case of physicians, you even have to have a buyout provision that there has to be a reasonable liquidated damages clause where you can, the physician can have a buyout where they can buy it out for so much amount. So that's really what the Texas non-compete is. So you can have a restriction, but the restriction has to be reasonable and it has to protect your legitimate business interest, not just trying to protect you from having competition or
Yeah.
paying your employees less wages so they don't go anywhere else.
Yeah.
So I don't know if that answers your question.
Well, it does to a certain extent, Ashima. And I'm very thankful that there are laws in place that kind of supports the H-1B program and the employees on H-1B, the H-1B visa holder as well. Because what employers do not recognize is that they're not just losing out on talent by restricting them in this way, but they're also messing up with the person's immigration status completely, and not just that person's, but also the family that comes with
That's
that
true.
person, right? So it's really they're uprooting an entire family from United States of America by enforcing these clauses, because I guess employers pretty much know that H-1B visa holders can't quite go easily anywhere because of the way of their visa status, you
No,
know.
you're right. But, I think President Joe Biden is coming on very hard on them now. In July of last year, there was an executive order passed where he actually told Federal Trade Commission that, you have to not have these non-competes. He's completely against the non-compete. So there was rules, and I think this year the Colorado state actually made it criminal for having a non-compete, except few clauses. So you could actually be in prison. They made it criminal, and I was surprised. I think Colorado was one of the first states to make it criminal.
Yeah.
Then Oregon said, you cannot have non-compete for somebody who's less than, I think they have it about 100,000. So, and it has to
Okay.
be limited to 1 year. So the non-competes to be valid, first, you have to they have to be reasonable. Apart from being reasonable, they have to be limited in scope, time duration, uh, I think, in the area, the geographic area where it is. So it just have an
Yeah.
overbroad, it's going to be unenforceable. Some judges would reform, and reforming is a fancy way of saying that they reduce to make it valid, but some states outright say no, they're not going to reform. Like there was a case where there was a buyout provision in the Texas case, but the judge said, I'm not going to reform the amount. The amount is too high. You
Yeah.
did it. I'm gonna just void it.
Right.
So, and then some people forum shop. Like Florida is very friendly to non-compete, but they say you can't just have a, a forum where there's not much relation and try to forum shop. It has to have some legitimate interest. So I think it's very, very important to have non-compete narrowly construed. And then in Texas, it has to be ancillary to the main legitimate contract. So you can't have non-compete on its own. Say now
Yeah.
people are interfiling, or so the employer comes and say, okay, here it's non-compete. In Texas, you can't do that. It has to be part of the main contract.
Yeah, I mean, these are some amazing things that you've just mentioned here, Ashima. But from a visa holder's perspective, if an employer asks that person to sign a non-compete at a stage where that person's green card is at stake,
Sure,
because these dates don't get current often. It happens
sure.
probably once in a lifetime, really, at this point,
Uh-huh.
right? So, and it's a very small window. If they miss their window, the visa holder will miss the opportunity of becoming a green card holder. And that's what is at stake. So, can employers really force their employees to sign a non compete?
Well, they can force, and I briefly mentioned about the previous case I had. So that was
Yeah.
a case about in think 10 years ago. So in that case, very similar. They had a small window to file for 85. The employee did sign the non-compete, but it was signed in duress. So even if they sign it's not going to be enforced.
Okay. Okay.
It
So
has,
that's great to know.
yes,
That's great to
it's
know
not
that
going to
it
be
cannot be
enforced.
enforced. Perfect. Perfect. So, it's half an hour has gone by. We are literally in the last 3 minutes of our discussion, and this has been such an eye opener. And I'm sure for you also, audience, this has been quite eye opener. If you're in a situation like this, all right, feel free to reach out to us. Yeah, sometimes when you are in a situation like this where there's a lot of pressure, the employer is pressurizing you, and then there's a small window where you have to file for your green card, and you don't know whether the dates would retrogress or what's going to happen with you. Well, we have attorneys here who can file litigation. We have attorneys here who are experts and who can guide you just the right way. info@chugh.com. That's our email ID. www.chugh.com. That's our website. And if you have any questions, feel free to send them to our comment box. We continue to monitor it, and we'll reach out to you. Kirti, very briefly, I want to ask you this question because we literally have 2 minutes left. What can an employer do to protect their trade secrets?
Well, you know, I think aside from what's normally you can do to protect trade secrets, you can't really have any, and from an immigration standpoint, there aren't any additional things that you could do. You can't, threaten. I can tell you what you can't do. You can't threaten the employee to, withdraw their H-1Bs and whatnot to while they're, trying to switch their employers and whatnot. But there's nothing additionally you can do, especially threaten from an immigration standpoint, to protect your trade secrets. I think Ashima might have a better idea on how to handle that question.
Sure. Uh, from the contractual standpoint, you can have a non-solicitation clause. You could have a non-disclosure agreement, and you must always have a liquid damages clause and that has to be reasonable. So I think you should always have that. So, and don't make it in the middle of the employment. Make it beforehand when you actually hire an employee. Make it at that point, because you have to show that it is supported by consideration. So when you have something like this, when you're interfiling, when the numbers become current and you present as contract, it just shows that this wasn't any legitimate business interest you're trying to protect. So it was just your personal agenda for the employer trying to focus on. And it's going to be unenforceable even if you do that, and even if a person signs it, and it's going to be ultimately voided.
Yeah, and
Yeah.
just to add to that, liquidated damages, you just have to be slightly careful that there are in relations to something else besides immigration. And I
Yes,
say this because
true.
when I've seen a lot of situations where there are liquidated damages in DWell audits and USCIS site visits, when there are liquidated damages, and they amount to very similar to what the visa fees are. So they're just wording it differently, but that's just another way to reclaim it. And the DOL officers and the USCIS officers are very well aware of this strategy. So make sure if you're going to have liquidated damages, it's related to something else altogether, not the same or similar amount to the H-1B fees
Thank you,
or
Kirti. I
fines.
think thanks for clarifying. But you're right. It should not appear to be a penalty. It doesn't, it shouldn't be appearing to
Right.
be a penalty. That's the key here. It has to have
Right.
reasonable protection of trade secrets and confidential information that you might be giving it to the employee. So it's solely for that purpose.
Yeah,
Exactly.
and with that, we've come to the end of our discussion. Thank you so much for joining us today. A big thank you to our attorneys, partner and attorneys, Ashima Chock from Houston, Texas, and Kirti Kalra from Santa Clara office, and to all of you for joining us today. Like I said before, this discussion is for informational purposes only. Whatever we discussed today does not create an attorney-client relationship. If you have any questions for us, info@chugh.com. We'll be ready to help you. See you next week then.